U.S. Supreme Court rules police must have a search warrant before testing the blood of a suspected drunken driver.
That could change the way Minnesota police handle DWI cases. Attorneys and local law enforcement are weighing in on the decision, and Renee Bonneau joins us with what they had to say. Renee?
Mike and Alex, DWI defense attorneys say it's a victory for the Constitution. Prosecutors and local law enforcement, meanwhile, say it's simply an added step in the fight to keep drunken drivers off the streets. But all sides still have questions about what this could mean for Minnesota.
Anything to drink tonight?
Wednesday, the U.S. Supreme Court ruled law enforcement officers must have a driver's consent or a search warrant before taking a blood sample in a DWI investigation. Attorney Jim Ventura says the Supreme Court justices were not crystal clear on what constitutes consent, and it could be up for debate, especially in Minnesota, where with every driver's license comes implied consent, and it's considered a crime to refuse a blood test.
Because I sought a driver's license when I was 15 and 16, that I gave up a Fourth Amendment privilege to be free from unreasonable searches. It doesn't exactly make sense.
The justices said unless there's an urgent need to draw blood, officers should be able to get a search warrant within a reasonable amount of time.
The United States Supreme Court has acknowledged that today we have telephonic warrants, meaning that you can just pick up the phone, call a judge, tell him what the reason is.
It does change how we do business, but it's not going to stop us from trying to take drunk drivers off the street.
Maple Grove police have consulted with their city prosecutor and say they'll make changes according to the Supreme Court ruling. They say the ruling will mainly be a factor in cases of criminal vehicular homicide or crashes with injuries.
It does add another process as far as getting a search warrant, but you know, we'll get a search warrant and we'll still get the necessary evidence that we need for prosecutions.
The Supreme Court decision rejected ideas raised in two recent rulings by the Minnesota Supreme Court that stated it's okay for police to force a blood sample from someone because alcohol dissipates from the bloodstream in the time it takes to get a warrant. The latest ruling likely won't affect past DWI cases, but attorneys and law enforcement say it could make a difference in pending cases. Mike and Alex.
All right, thanks a lot, Renee.